Oh, yes, sir. Come on, thank you. Wiley, thanks for being here today. If you would just push the button there on that mic in front, it should turn green. And if you would just your name and who you're representing here today, which would be Home 2 Suites, please.
My name is Cameron Wiley, and I'm the general manager of the Home 2 Suites in Conway, Arkansas.
All right, thank you for doing your civic duty to be here today. We appreciate it very much. I am going to place you under oath. If you would please raise your right hand and do solemnly swear and affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir. Mr. Wiley, there's no reason for us to think that you have participated in anything that is out of the nature of complying with law, but you can provide some information, and that's what we're looking for today is just some information. As you heard me say a while ago, we're trying to look at the process, see if we need to change the process or see if the current process has been violated. So just a few questions for you, if you would, please. You're the general manager of the Home 2 Suites Hotel in Conway, correct?
Correct.
Okay. And during a period of time this last summer, you had quite a few folks that were staying with you that were there for the purpose of gathering signatures. Is that your understanding, or do you have any knowledge of that?
That is my understanding, yes.
Okay. And those individuals, when they registered, did they register individually, or were they registered by somebody else to stay at the motel?
The majority of them were registered by a singular individual. Very few of them registered under their own name.
Okay. What was that name that they were registered under, please, sir?
The name they were mostly registered under was Conrad Reynolds.
Okay. And how was the room paid for? How were the rooms paid for?
The rooms were paid for by different means. There was one, when I say one, there was one giant check for $13,000 that was split between multiple rooms, and then towards the end it was paid for with a credit card.
Okay. And the credit card was in whose name? Do you remember that?
That I do not know. I was not the one who actually asked you.
Okay. Do you remember the time frame, or do you have the time frames in which the individuals were at the hotel?
Yes, I actually printed off all of the registrations for the rooms that were under Conrad Reynolds, as well as a few of the other ones that I was able to pick up. Some of them were short stays within the middle of July. There's one right here that started in mid-June and didn't check out until early August. Those are going to be the time frames that are for almost all of these stays.
And early August, do you happen to have that date in front of you? Was it August 4th, 5th, 6th?
That was the date of checkout here. As I said, I have about 15 receipts. This one was August 5th, so if they didn't check out in that time frame in August, it may have been like half of the stay where they checked in June and checked out in July.
Do you happen to have the names of those that were there after August 5th?
The only one that I believe I have the name of as far as being there after August the 5th was a Gail Golek. She checked out on the 7th. That one is, we checked out before, and then the last one. This one checked out in July. So only Gail Golek from the records that I have as far as names that are not Conrad Reynolds checked out after the 5th.
Okay, and that's spelled G-A-I-L, and then the last name is G-O-L-E-C.
That is correct.
Okay, and that was August 7th, you said?
That's correct.
Okay, and as far as the, say again, the addresses that they registered under, do you know what addresses you have them registered under?
All of the addresses, with the exception of one, were registered to a Conway address, 4699 Prince Street, Unit 9 in Conway, Arkansas. The only one that wasn't that address was the Gail Golek, who had an Arizona address.
Okay, so all the other ones were actually registered at the motel under the Conway address?
That is correct.
Okay, not individualized like their driver's license or address on their driver's license?
That is, yes, they were all under that Prince Street address in Conway.
Okay. Did you check with your corporate legal before you came to testify today?
I did not.
Okay. Do you know of any reasons why we couldn't have copies of what you brought here today, or do you need to check with your legal to see before you release those to us as a committee?
I can check with with legal. Unfortunately, my human resources director is out today, and so it wouldn't be until tomorrow until I get a pinpoint on that. But I can check to see if there's somebody else that would have the knowledge on the procedure for releasing this.
Okay, so what I'd like to ask you, because I don't want you to be in trouble, I don't want us to be in trouble, anybody else to be in trouble, would you check with your corporate legal, please? And if you are able to release those to us, would you, you'd be willing to do that if you get the clearance? Is that agreeable?
Yes, I'd release these to you.
Okay, and final question for me. Are you owed anything? Have you been paid in full?
From my understanding, none of these have any outstanding balances. Everything was paid in full. There's no bad debt accrued due to all of these states.
Okay, and what was the total amount you were paid again?
I didn't add all
Well,
that
you
up.
mentioned a number a while ago. Was it 13,500 something?
So that was a check that was paid to cover the outstanding balance, and that was in July. And then so there was probably another, I'd say, just an estimate, another 11 to 13,000 that was accrued from that point on forward. So probably about 24 to 26,000.
Okay, I'm going to recognize Representative Gray.
Good afternoon, Mr. Wiley. Just a couple of quick questions. $13,000 sounds like a lengthy hotel stay, or maybe there were a lot of people there. Can you estimate or tell me how many individuals were with this group that were staying at the hotel?
It would have to be an estimation, even though I do have the amount of rooms, which I added up to 15 stays. That doesn't necessarily mean there were 15 people. Some of the rooms could have had double occupancy, so it could have been more than 15. But I would say that at least 12, definitely not less than that.
And I don't know if you had conversations with any of the guests at the hotel, but did any of them happen to mention to you or allude to the notion that they were being paid to be there, or whether they were doing paid work while they were there?
No, I did not have any type of conversation with them. They were there to do a job, and generally speaking, if I'm talking with a guest, it's either there's a problem with the stay or they are there on leisure and we're just having normal, regular conversation. If they're on work, I leave them to their own devices.
I understand. Thank you.
All right, Representative Wooten.
Thank you, Mr. Chairman. Mr. Wiley, do you check out each day at the service desk?
I don't actually work with service desk. I have front desk associates and guest service agents that do the check-in and check-out process.
Okay.
Usually in the back.
Do you review the checkouts?
If there's any kind of abnormalities, like if there's a state that doesn't have a resolved amount, say they have a credit card that's declining, or if it's an issue with a guest, then I will review that. Otherwise, there really isn't much need for me to go through and check every single individual reservation.
Would you call a $13,000 check an abnormality?
It is 100% an abnormality. When I received that check the same day, because I wanted to make sure that we got paid for our services, I immediately took it to our bank that we use for all of our deposits. Everything cleared, so at that point, I didn't have any reason to think about it any further.
Okay, does your bank keep a record of that check?
I'm pretty sure that they would keep a record of that check. Yes.
They would copy the check, but you didn't approve the check.
I'm sorry.
You didn't approve the check at the time that it was written. They didn't call you and ask you, or call you to the front desk and say, will you approve this $13,000 check, or do they have the authority to accept that?
They checked with me before they accepted it. They came to my office and asked, would it be okay if the group used a check to pay for their outstanding balance that they have so far? And whenever I did the calculation, it came out to $13,000. I said, I normally don't do this, but go ahead and write it, and I'll immediately take it to the bank and make sure that it clears.
Okay.
And so I approved that.
You had, in other words, you had several possessions of the check.
Several possessions.
Well, I mean, a period of time, you had the check. You had the check in your office from your service clerk, from the desk clerk,
For about an hour. Yes.
for about an hour. And you didn't notice the name on the check?
I did not pay much. I think it was Conrad Reynolds, but I don't.
You think, or do you know?
I think.
Okay. Could you, if it's permissible, Mr. Chairman, I'd like to see a copy of that check if he gets approval from, his legal, that it's, permissible, that he can get a copy of that check from the bank for us.
Yes, sir. I'll make that request. If you get it cleared with your legal, we'd like to see that, please. Okay?
Thank you, thank you. Thank you, Mr. Chairman.
All right, thank you, sir. All right, any other questions from members? Representative Allen?
Yeah. Thank you, Mr. Chairman. Mr. Wiley, I just want to ask you a personal question. Did you get permission from your legal division to come down here and testify today before you came in?
No, I did not ask for legal permission. I was served this subpoena from a state trooper, and so I felt that it was my duty to make sure that I had all necessary information pertaining to this case with me. But no, I did not clear it with the corporate office.
Hypothetical situation. Can I follow up with my quick question?
Yes, sir.
Okay. If I'm a guest at your hotel and somebody call your front desk and ask if Fred Allen is a guest at your hotel, do you all give out that information?
We do not give out that information. As a guest at the hotel, we are obligated to protect the identity of all those that are staying with us. So we usually say we can't give out that information. Now, if somebody says, I'd like to be connected to this person's room, what we do is we call that room and ask the identity of the person who's calling, and then we place them on a hold. Call that room and say, do I have permission to connect you, to connect this person with you? And if they say no, we do not do that.
I guess my question is, did you have permission to release this information to us today?
I was not given the permission from corporate office, as I said before. I didn't release this, but being is that this is information that is directly pertaining to this case, I brought all of the substantial items.
Thank you.
Mr. Wiley, you were served with a subpoena, correct?
That is correct. Two different instances, one through email digitally, and then one with a state trooper.
Okay. Well, thanks for being here, because in the subpoena that you were issued, not only were you subpoenaed, but your records were subpoenaed also. Don't know if you remember that or not, but in that subpoena, Representative Allen, those records that he has he was instructed to bring them with him. As a matter of courtesy, we are asking, before they're given to us, that you just check with your legal, because wherever this goes, if it goes anywhere, we want to make sure all the T's are crossed and all the I's are dotted. But in the subpoena, those records were requested to be brought so we could establish some things here today. All right. Are you done there, Representative Allen? Or?
Because I just want to make sure that Mr. Wiley was not getting in any trouble coming down here by giving us this information today.
Yes, sir. And that we want to protect him and all of those that are coming today, because we're just after the facts. So, all right. Mr. Wiley, we have no other questions for you at this time. Perhaps if you don't mind, if you stay around, that's great. If not, we understand. We appreciate you being here today. Okay?
Okay. Thank you.
Anything else you want to add? Anything you want to share?
I did have, so this is probably related, but it has nothing to do with their stay. Case in point, I did have some mail come to some of the people that were on the subpoena. We didn't have their names on the actual room records, but from my experience, the only time that you have mail forwarded to a hotel is if you're staying there for an extended period of time, or if it's something that's an emergency, and this being from, from the Bureau of Legislative Research, I didn't think that it was an emergency thing where it had to be out 1 or 2 days. So that establishes a record of temporary residency.
Right, which you were not able to deliver those because they were no longer there, is that correct?
That is correct. Also, because their names weren't in our registry, we couldn't look up to see a recent address. So I figured I'd bring them here.
So you really didn't know whether they were in state, out of state, all you had to go off of was the address that was given to you, right?
That is correct.
Okay, thank you. All right. Members, at this time, I'd like to call Stephanie Johnson, Justice of the Peace Elect for Slim County District 12, and Lori Justice Citizen. And while they're coming to the table, members, one thing I want to point out is you have a affidavit in your packet from Amanda Berry, who's a notary, and she has substantiated, if you look at point number 3, then on the 10th day of July, she notarized signature sheets for petition to include paper ballots in Arkansas elections at the county level, and the current resident address were not redacted at the time that I notarized them. So she is substantiating that when she signed the form, that there was not a redacted address on it at the time. And she had that notarized by somebody else, by the way. All right, thank you, ladies, for being here today. If you would, please state your name and your title for the record, and I'm going to put you under oath, please. And just push that button right there in front of the election turn. There you go.
It's Stephanie Johnson, JP Lecture, Slim County.
And Lori?
Lori Justice, citizen.
All right, thank you all. If you would please stand, I'm going to put you under oath, if you would please. You both solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
Yeah.
Thank you. All right.
Mr. Chairman, I would like to read a statement before we begin, if I may be permitted to do so.
Yes, ma'am, go ahead.
I'm a Republican nominee for Justice of the Peace. I am unopposed in the general election and therefore am a JP elect in Saline County. I helped gather signatures to the ballot initiative. First, in regards to Mr. Lancaster's testimony, he and Mrs. Lancaster have told multiple lies about a dozen people and quite a few occurrences within our committee. So I'm not sure how much we can believe the testimony. In fact, I do not believe much of what he has said. He was untruthful in his previous appearance before this committee in regard to his involvement in the ballot process. He made everyone believe he had no knowledge of the happenings within the ballot committee until after problems were discovered, when in reality, he was involved in the entire process. Second, on my assistance signature gathering for the ballot initiative, the facts are as follows. In the spring of this year, I learned about a chance to possibly paper ballots in Saline County and jumped at the chance to organize a petition drive. I created a text thread to communicate with volunteers and began to set up collecting signatures. I needed a little help organizing, and Lori Justice offered to help me. We worked together to keep the volunteers motivated, including passing out water and letting them know about various events where we could get signatures collected, such as fireworks shows. Signature sheets were gathered weekly by various representatives by the ballot committee. On the final day, a ballot committee representative brought the box of signed petition sheets, and he, Lori Justice, and I turned them in. I was never paid for my services. I was only a volunteer. I worked solely with other volunteers, and I did not organize paid canvassers. I do paper ballots, which has now have become a plank of the RNC platform, and I worked hard to get this issue on the ballot in Saline County for voters. Thank you.
Thanks very much. The questions that I have for you are this. We have established today that when the notaries signed the forms, that at least on in 2 areas, Conway and Saline, that those were altered between the time that the notary signed them and the time that they were turned in to the county clerk, specifically Slim County. It was given testimony to the previous committee by County Clerk Doug Kurtz, I think I saw the room here today, that y'all two and a gentleman which is unknown accompanied y'all to turn those into the county clerk. Is that accurate so
That's
far?
right, yes.
Okay. Who is the gentleman that was with y'all, if you don't mind, please?
It was Will Huff.
Will Huff, okay, thank you. And so here's the question. What we wanted to know is, between the time the notary signed them, and y'all were the last ones to touch them, to turn them in, right? Those addresses got altered by somebody. So did y'all alter the addresses?
We did not know.
No,
Okay, do you know who did?
We
no,
did not know.
Who did you get the petitions from?
It was Will Huff who gave us the box of them.
Okay, so you took possession from Will Huff then?
Yes, sir.
Okay. Did you look at petitions between the time you got them from him and turned them in?
No.
Lori?
no.
Okay, okay. And what we're trying to do is chain of custody, because somewhere between the time that the notary signed them and the time they got turned in, they were altered and that the addresses were redacted, and that's what we're trying to get to. And that's why it's important for y'all to be here, and we do appreciate y'all being here. So do you have anything that you think you can share with the committee that would help us determine who it was that altered the addresses?
Nothing that I'm aware of, no.
Okay, all right. Any questions from members? Representative Ray.
Thank you, Ms. Justice and Ms. Johnson, for being here. Just a couple of quick questions to follow up on that. Has anyone from the ballot group that organized this effort, has anyone from that group reached out to you in advance of your testimony today about your testimony?
No.
Tom Reynolds told me.
Can you provide us with some sort of content about how that conversation went? Did he instruct you on what to say or anything to that effect?
Now he just, I guess, encouraged me to just tell the truth and what I have done.
And we certainly appreciate that. My last question is on our, I don't know if you had a packet that was handed out today. There's an exhibit here, C2. I keep seeing this name both in the packet on C2 and in the forms on C3. Do either of you know who Joshua James is, or Joshua James Lawrence, or Joshua James Ryan Lawrence?
I have never heard him before.
I've never heard of it until
I don't
I was
know who he
listening.
is. Yeah, I didn't know. I don't know who he is.
Okay. And both of you said you were volunteer signature gatherers, correct?
Unpaid,
Correct.
yes.
Mr. Lancaster, in his testimony last time, said that I was a paid canvasser, and I want to state on the record right now, I wasn't even reimbursed for my expenses, such as fuel, or if I went and bought waters for the volunteers. We worked strictly with volunteers, and we were volunteers ourselves and never received a dime.
Right.
Okay, gotcha. And did you, in the course of volunteering, did you meet any canvassers that were not from Arkansas?
Yes.
Yes.
And did any of them, tell me about that. Where were they from?
I didn't talk to them. Most of the time when I made contact with them was when I was out delivering waters. Understand, they didn't even come on the scene until later on. She and I were doing volunteers at first. That's all who was out in Saline County. So what I would do is drive around, and this was only on occasion. It was really hot, it was June, July, and take waters to people. So if I saw the orange van out there, I would pull over. Even though it wasn't our people that we were working with, I would pull over and see if they needed water or whatever. But I never really got into a conversation with any people who were from out of state. Our people were mostly Saline County Republican Committee volunteers.
Okay. And then going back to this exhibit C2 that's in the packet, this appears to be a Facebook post advertising that if you're a non-Arkansas resident, you could be paid $1,200 a week to gather signatures. Were either of you aware of an effort to pay people from out of state to come in and gather signatures?
I knew that some of them had been paid. some people were paid, some people weren't. Our people weren't paid. So like I said, I didn't have anything to do with that, and neither did she. I did have a phone call, and I noticed Mr. Johnny McMahon is here today. During the course of this, he did reach out and call me and talked about us getting signatures. And he mentioned, about being paid, and I told him we're not paying. This is totally volunteer. We're 100% volunteer, and that's all we dealt with. So as far as, who got paid what or who stayed where or any of that, that was nothing that we dealt with. Right?
Sure.
So, and
Okay.
I do want to say something. In his testimony last time, he did make a mistake, and I don't think he did this purposely, but he did say that she and I told him that it was hard to get signatures, and I do want to say it was not hard to get signatures. It was hard to get volunteers to go out and get signatures. So I want to clarify that for the record.
Who was it that said that?
Mr. McMahon.
Oh, okay, gotcha. Well, thank you to both of you for being here and for sharing your testimony with us today.
Anything, not the subject of should we have paper ballots or should we not, but along the lines of the discussion of what we're here to meet about today. Actually, sorry, I'm gonna go to Representative Wooten. I did not see it. Representative Wooten, go ahead.
Thank you, Mr. Chairman. Ladies, did you receive any other type of compensation besides a check? Did you receive a gift card?
Absolutely not. No.
You didn't receive anything
No.
from them? Okay. How were the petitions given to you in a box? What type of box? Was the box covered?
Yes.
Did
It
you-
was a clear, like
A Tupperware box.
Did you-
Walmart.
Okay. So you could see the contents of the box?
You could see them through the side. The top, it was a plastic box that had a solid colored top. So you could see them through the sides, but you couldn't see through the top.
Did you open the boxes and look at them?
No.
So in other words, your testimony before and under oath today is that you didn't see any of the black lines that were on our documents here today, as Exhibit C3 shows.
Correct.
For
We
conflict.
did not see those, no.
You didn't see any marks on any ballot, on any petition
No.
or notary.
No.
All right, thank you. Thank you, Mr. Chairman.
Thank you. Representative Tosh, Dwight Tosh.
Thank you, Mr. Chairman. I want to go back to a question that was asked of you a while ago. You said that you did receive a phone call, and I wasn't really sure who you said called you prior to your testimony before you appeared before this committee today. Who did you say made that phone call?
It was Colonel Con Reynolds.
Okay, about how long did that phone call last? 5 minutes, 10 minutes?
Maybe a half hour or more.
So in a half an hour conversation, the only thing that you said a while ago that was said was that he encouraged you to tell the truth. So was that pretty well in a half an hour? That was it in the conversation, just tell the truth, nothing else about your testimony here today?
And we talked about the process of signature gathering and all of that, and how he believes that there were no laws broken. And I'm not a lawyer, and I don't know what the law is, so that's what we discussed.
Okay, in no way was that conversation in any way to influence you regarding your testimony here today, the 30-minute conversation, none at all?
May I make a comment?
Yes, ma'am.
Because Colonel Conrad Reynolds' name is being thrown around a lot today. And I do want to say from experience that I've known him for several years, and Will Huff as well. And I believe that they are honest people, and they would not do anything unethical without knowing about that. I believe that they operated under the advice of their attorney. And while you may not agree with his stance on paper ballots, which some of you may not, he's not a dishonest man. and he has top secret security clearance. You don't get that by not following rules and laws. So I just want to say that.
You referenced the attorney. Who was the attorney that he was taking instruction from?
That would be Clint Lancaster, I believe, was the attorney for REIA, which is the paper ballot committee that did this initiative. The county initiative was not ABII as referenced in your last meeting. It was REIA, was actually a ballot committee.
And do you know that that's actually a ballot committee that's registered?
Yes,
with the
I looked
state?
them up.
All right. Senator Dismayne, let's go to you first.
And just make sure I understand, so there's a separation between Mr. Lancaster and Conrad Reynolds, or
No, he's their attorney.
they are working together? Okay, I was trying to make sure I understood.
He's
what you were saying.
the representative, he's their attorney.
Okay. So there's not a separation, but you believe one may be doing something somewhat nefarious and the other is
No, I
not,
don't
or-
think anyone's doing anything nefarious. What I'm saying is that, that I believe that anything that EIA has done, most likely was done under the consultation and advice of their attorney.
Okay, all right, thank you.
Senator Johnson.
Thank you, Mr. Chairman, and thank you, ladies, for being here. Full disclosure, Ms. Justice, you're chair of the Pulaski County Republican Committee.
Correct.
I'm a member of your committee, am I not?
Yes.
I just want to fully disclose that. I want to emphasize to not just these witnesses, but all, that we're not probing into the character of anyone involved in this process. And people can be of great character and either with a mistake or even a misunderstanding of the law, violate the law. And a lot of people have come forth. At the last hearing, there was a discussion between the difference between domicile and residence. And perhaps that needs to be clarified, but I just want to emphasize, if you please limit your testimony to the facts, because that's what we're doing here. When we ascertain facts, it helps us to pass better laws and to correct issues where the law may be unclear. So I want to emphasize that to you. And again, I thank you both for coming and for your testimony. Thank you, Mr. Chairman.
I have nobody else signed up to ask any questions. Just give y'all opportunity. Any final comments y'all would like to make? Okay. Appreciate y'all being here. Thanks for being here today and for sharing with the committee. All right. Next up, I'd like to get Graham Sloan to the table, please. Graham, if you would please name and title for record, and we'll put you under oath too. Everybody should be put under oath today.
Graham Sloan, Director of the Arkansas Ethics Commission.
Thank you. Do you solemnly swear and affirm that the testimony about to give be the truth, whole truth, and nothing but the truth, self and God? Thank you. Representative Ray.
Thank you, Mr. Sloan, for being here. So I guess to start with, can you please explain or outline when or under what circumstances a group is required to form a ballot question committee?
Yes, let me begin by saying that the Arkansas Ethics Commission has jurisdiction over a number of areas, and one of those areas is the Disclosure Act for public initiatives, referenda, and measures referred to voters. That act contains registration requirements that aren't applicable to everybody spending money, but there are reporting requirements that are applicable to everybody. A ballot question is a question in the form of a statewide, countywide, municipal, or school district initiative or referendum. It's basically a question that's going to get presented to voters at an election. You become a ballot question committee when you receive contributions in order to expressly advocate the qualification, disqualification, passage, or defeat of a ballot question. And then the trigger for registration on committee is within 5 days of receiving or spending $500, and then reporting, the trigger for reporting, even if it's your own money, even if it was an individual spending his or her own money out of their paycheck, or if it was a business or other entity that was spending its own money out of its corporate treasury, it would trigger reporting during the month in which it spent $500. And so essentially, if you're out there expressly advocating the qualification, disqualification, passage or defeat of a ballot measure, you're going to trigger reporting. And if you're receiving contributions to do it, then you're going to trigger registration as a committee as well.
Okay, thank you for that. And so the requirement to form a ballot committee after you've raised or expended $500, is that applicable to both a statewide measure and a local measure?
Yes, the definition of ballot question includes statewide, county, municipal, or school district initiative referendum. So it really doesn't matter what level of government you're at. It applies.
And are there any ballot question committees that have been formed related to the subject matter at hand?
There was a group called Restore Election Integrity in Arkansas that filed a statement of organization back on October 19th of 2023. One of the required information fields is what ballot measure or ballot questions you're seeking to influence. And on that original filing, the group had registered and indicated that it was going to be advocating with respect to a constitutional amendment to require hand-marked ballots, and to the extent that it's a constitutional amendment that be statewide.
So what about for these various local measures? I think there's 7 or 8 different county level measures that were or are being pursued. Were there ballot question committees formed for any of those?
No, sir. We looked, and then I will say that this morning, Restore Election Integrity in Arkansas had faxed to the commission an amended statement of organization that did indicate that it was going to be engaged at the county level. The group had previously not filed any reports, but the amended registration today was accompanied by 9 reports that reflected activity and financial activity. I think it was the reports were January through September, and I don't think there was any. I don't think they crossed that $500 threshold until maybe June. But so the June, July, and August reports did have significant financial activity reported on.
Okay, and can you repeat, when did you say you received those reports?
This morning about 9 a.m.
Okay. Let me ask you this. If a group just fails to register and then it becomes obvious that they're expending money in excess of $500, you don't have a way to contact them. You don't know who they are. How do you handle a situation like that? I mean, how would someone even file a complaint against a group that just completely fails and neglects to register?
I think that's a good question, and I'm not sure how you would seek to find out of the identity of the people behind the group. I mean, they'd have to do something to make that information available. You know, that sometimes you could have a newspaper ad, and we've seen this where there's a newspaper ad and it attributes the activity to a particular group, and then you can't find any information on that group. So, I mean, the identity of the person that's receiving the contributions or making the expenditures, that's necessary if you want to pursue non-compliance issues. You need the identity, and I don't know how you would get it other than somebody would have to tell you. You could, if it was a newspaper ad, maybe you could contact the newspaper and see who paid for it. But
Okay. And then the filings that you received this morning, are they posted on the website, or will they,
Yes.
when would they be posted?
Well, they were received by facsimile, which, in order to perfect the filing, the original will have to be received within 10 days. But when we receive facsimile copies, we do stamp them receive and put them on the website. And then when the originals come in, if it's within 10 days, they would be stamped file, using the date of receipt of the fax, and then posted, within a reasonable time.
Okay. All right. That's all the questions that I had for you. Thank you.
Senator Rice?
Thank you. Mr. Long, thanks for being here today. Just thinking about, there's so much of the stuff we've seen over the years, the only way that you can have anything to do with anything is if a complaint's filed. Is that correct?
Yes, the commission's does have investigatory powers. It can issue subpoenas and take sworn statements, but those powers do not attach until there's been a complaint.
But it would take, as far as your knowledge, it would take the legislature pass anything to put something on. If somebody turns in a ballot initiative, if it has a law attached to it that says you've got the Ethics Commission has to sign off that you're a registered deal, that would have to be changed, would it not?
Currently, we are the filing office, but there's no, we don't check anything.
Yeah, for them to turn in a ballot, it would take us to pass a law and say, we've got to have an okay from the Ethics Commission saying you have registered as an official legal group to attain signatures with that. But that it would take a law to do that. That's all right.
Yes, other than you could have them submit a
Affidavit or something.
a certified copy of the statement of organization. That would be a document that we, somebody requested one, we do that quite often, provide certified copies of filings, I'm sorry.
Just for curiosity, how long has the $500 threshold been in effect?
To the best of my knowledge, it's always been $500, and so it would just go back to the,
With inflation, is there been any talk about raising, that wouldn't affect this case, but with inflation, have we talked about whether that, what would it take to raise that to $1,000?
no, sir, I've not heard any conversations, and it looks like this act came on the books in 1989.
So it take legislature again to even change that?
Correct.
Okay, thank you, Mr. Chair.
Senator Dismick?
But I guess really I'm curious, so if there was one entity that was petitioning multiple governmental bodies, so, or creating petitions for multiple, so, within White, Lieber, Saline, I don't know what's going on, but, White City, where does the threshold have to hit at each one of those, or, would they have to have a separate ballot committee for each one, or how does that work for someone that's, it's not like there's a ballot committee, it's not a, for the state, it's for each county.
Yes, registration though, the Ethics Commission is the filing office, and so if somebody wanted to register for a statewide question, it would be with us. If it was a countywide question, it would be with us. A group, I don't know that the law specifically addresses it, but the form says to list the issues that you're going to be advocating. So I think that you could list more than one issue. And if you were interested in a countywide matter that was in more than one county, I think you'd list them on there. But then the $500 threshold would just apply to your activities, and it wouldn't be $500 per county. It would be $500 total.
So on that, whatever you received today shows that because they're each separate, right? You're still only, you can't have one petition for both White County and Cleveland County. You have to have petition for White, petition for Cleveland, and they can each and every one of those be different in some way, but still would be ran by the same organization. So I guess I'm just I'm trying to see what should we expect to see then on a filing? Essentially, we're for paper ballots of some sort, and then we, a petition for, that says this for White County, petition that says this for Cleveland, petition. What is that? What it should look like, or for one of these groups that's operating in multiple counties?
Well, I think it's gonna change depending where in the process you are, that if somebody was trying to get, I'll just say wet dry. I'm just trying to get, there was a wet dry issue that they're trying to get the ball rolling on in a particular county, I think they would register for just wet dry Craig County. And then, but I mean, once, if they got enough signatures and it qualified for the ballot, and then, you know, that it got assigned a number or a name, then I think you would, you know, if somebody got involved at that point in time, I think it would be, you know, that measure which could be presented to voters, you know, on, you know, election day, and, you know, so the, you know, somebody's registered on one of the, you know, issue 2 casino, it would just be, you know, issue 2, which is being presented to voters, you know, November.
But what I don't understand is what is even expected to be presented, because the petition for White, Cleveland, Faulkner, I don't know where all they were,
Right.
are all separate. They cannot impact the other petition.
Right.
So whenever they report their expenses, for instance, do they have to allocate them per county for the work that was done there, or can they hire the same person from out of county who works in Saline, Faulkner, Cleveland, whatever it may be? I'm just trying to understand what should we be looking for on the filing if we were to review the filing? I mean, can I look and see who all and how they were paid for to work in, like I said, White or Cleveland, or is it all just going to be one big number and you're just kind of left to try to discern on your own?
Well, the law actually used to require a ballot question committee to report the names and amounts paid to canvassers, and then that requirement got struck down. It's my understanding it was unconstitutional, and so that used to be required information on a report that would have been filed with us. Now, maybe just generically signature gathering would be an entry or an expenditure, but it wouldn't be broken down by county. And then I think you could, you know, if you registered for more than one issue, the law doesn't require that you break your expenditures or your contributions down by issue, but we do have groups out there that are interested in more than one issue, and they will voluntarily separate those activities onto different reporting forms. And so, you know, if you wanted it broken down, then, you know, perhaps the law could be changed to, you know, that you would report contributions, expenditures separately for each measure that you're engaging in, you know, trying to get qualified or disqualified passenger fee. But I think a group could register for more than one issue. I think as long as it was reported, it's, well, I don't think they'd have to report by issue. I think it just, hey, we're registered for these 3 issues, and here's the money we raised, and here's the money we spent.
They would have to list out the issues that they were engaging in. And in this case, since each one of them separate would be one, they would need to list each county, I would say.
No, I think the amendment that was filed today just said that hand-counted paper ballots at the county level. It didn't break it down by which counties or how many counties. It was just hand-counted paper ballots at the county level.
Do you remember the total amount of expenditures that were reported this morning?
I don't. It was, in looking through the reports, I saw one that was, you know, the activity was 100,000, and then I think, you know, another one might have been 65,000. So it was, you know, 6-figure. You know, the total was, the activities was at least 6 figures.
When should those reports have been filed, if they would have been filed timely?
When you cross the $500 threshold, when the group crossed the $500 threshold, which, you know, I didn't study them, but it certainly looked like that by June there was more than $500 worth of activity. So I'm prepared to say, you know, they would have triggered in June, and the June monthly report would have been due July 15th. Statement of organization would have just been due 5 days after you cross that threshold.
And Go ahead.
But I'm not firm on when they crossed the $500 threshold, but I do feel comfortable in saying it certainly was, by June, wouldn't have been any later than that.
And do you, well, I tell you what, I'm gonna let other members ask questions, and I'll come back. So let's go. We got Senator Mark Johnson, Representative Robin Lundstrom, and Representative Wood. So Senator Johnson, you're up next.
Thank you, Mr. Chairman. Mr. Sloan, thank you for your testimony. Senator Rice and Senator Dismay asked some of the things I was going to ask, but I want to get this thing about statewide or county by county clarified, because I think this may be a future problem we need to clean up. Let's say I want to create a organization to go out and get signatures to, let's pick something that's not controversial. Say we want to ban pit bull dogs in every county. I think it might be a little, give smiles out there, but it'll work for our purposes of illustration. Each individual county, the BQC would not, if they spent $500 period, even though they're hoping to do this in 75 counties, they couldn't spread that threshold over the total number of counties in the state. They'd have to, it would be 500 period. Is that correct?
That's how I would read the law. I guess the question is though, if you're trying to ban pit bulls in all 75 counties, is it going to be a constitutional amendment, or are you going to have each county pass its own ordinance?
Well, that was my point, is that for whatever reason, this group wanted it to be county by county. And if in that case, I'm wondering if there's a way to, the issue is not as relevant as it is the county by county thing. And again, your commission, and full disclosure, Mr. Chairman, my wife's a former member of the Ethics Commission, so I'm somewhat familiar. You're regulating the money spent to influence politics, not the political questions themselves. And so the thing that you would be looking at, and correct me if I'm not seeing this correct, is that someone spent money in Saline County or Cleveland County or Faulkner County or Conway County to enact a local ordinance in that county. That's the regulatory purpose. Am I reading that correctly? Per county.
I don't know that it is per county. I think you've got a group out there that's receiving or spending $500, and they're seeking to influence one or more countywide measures. And then I think the $500, it's not 500 per county. I think it would just be they're engaging in, they're trying to expressly advocate the qualification, disqualification, passage, or defeat of a question being presented to voters. And then if they spend 500, receivers spend 500 to engage in that activity, that they're going to trigger registration and reporting.
If they filed as the Saline County BQC and the Faulkner County BQC and the Cleveland County BQC, would that be three separate $500 thresholds?
I think it would, yes, because it's three separate committees.
So I guess going back to the first question I had, it really, if it's statewide, you could potentially create somewhat of a subterfuge, or at least delay your disclosure by breaking it down county by county, theoretically, of course.
It'd be the same reports filed at the same office at the same time, but
Once you hit the threshold in each county.
right.
Yes, sir. Okay. I'll quit now, Mr. Chairman. This is even more complicated than I thought it would be. Thank you, Mr. Sloan. Thank you, Mr. Chairman.
Representative Lundstrom.
Thank you, Chairman Hammer. I'd have a motion at the proper time that we refer this.
All right, I'll take your motion in a minute. Let's continue on. Representative Wooden.
Thank you, Mr. Chairman. Mr. Sloan, was the committee, and maybe was the committee that was in Faulkner County registered with your office, and the one that was in Saline County, were they registered with your office?
Certainly the only group that was registered with us was Restore Election Integrity in Arkansas. It registered back in October 19th of 2023. And at that time, it indicated that it was going to be expressly advocating the qualification, disqualification, passage or defeat of a constitutional amendment requiring hand-marked ballots. And then that registration was amended today to speak in terms of county laws at the county level. So there is but one committee registered, and then today was the first time that it indicated that it was going to be active at the county level.
Did they pay you $500 for each county or just $500? Or, I mean, I paid you, but have they collected? I mean, we've had testimony that a $13,000 check was given to a motel in Conway. Now, have they reported other expenses to you?
The reports came in this morning. I looked at them briefly on the way out the door, and there was, I think one of them showed $100,000 of activity. One of them showed $65,000 worth of activity. So they have reported significant financial activity, but what that is and what the various entries were, I didn't study it at that level.
So what do we have? We have two committees or we have one?
One committee.
One committee. And they've been in existence since October of 23. And here it is, October of 24, and they're just now reporting.
Yeah, by my count, 367 days after they registered. But again, the question would be, when did they cross the $500 threshold? Because that's when they would have triggered reporting.
But did they say that in the report to you when they crossed that $500 threshold?
No, you would just look at the report and then look at the dates for the contributions or the dates of the expenditures and just total them up till you got 500 on money in or money out.
So what are they registered for? For Faulkner County or Saline County or a statewide amendment?
Let me look at the statement, I can tell you. Give me just a second. REIA, which is Restore Election Integrity in Arkansas, will work at the county level to encourage residents of the county to exercise local control over their elections by advocating for paper ballots counted by hand in a manner that complies with Arkansas law.
So they didn't designate a county,
No,
specific county.
no, it's at the,
So that leaves the impression it's statewide.
no, it's,
I mean, would you assume that, or how would you figure out if it was do you care if it's a local versus a statewide amendment?
the information reported wouldn't really change, and so from our perspective, are they registered and reporting? And then I don't think the law requires a separate registration and a separate report for each county, for each separate ballot question, but that, that would certainly be y'all's prerogative to make that legal law.
So you would just accept it as a fact that they had a committee and not worry about the county or the state level? And I'm not saying that that's wrong. I'm just asking you, with a $100,000 expenditure and whatever else, and then a $13,000 expenditure that they had in Conway, what were they doing? Were they doing it for Faulkner, or were they doing it for Saline, or were they doing it for Sebastian, or were they doing it for 75 counties? I mean, I think the voters have a right to know if they vote for it and they live in Saline County, they'd be voting to have paper ballot.
They'd be voting for their county. I mean, whatever the question was on their ballot, it could be a countywide question that's being presented to them, or it could be a statewide question.
Okay.
But, you know, it's tied to the question that's being presented to the voters.
But anyway, the threshold was $500
Correct.
when they've expended it. All right,
Procedure spent.
thank you, Mr. Chairman.
You're welcome. A couple quick questions, and nobody else is on board right now. The report shows the source of giving, correct? Or contribution?
You know, I looked at the front page and it's got a summary for contributions, and there was information in that field, and so I would assume that there was itemization on the following pages, but, you know, it was just almost the last thought I had before I walked out the door was just to see if there's anything yet to be posted, and then, well, there was.
Okay. And the penalty that is assessed, or what's the punitive damage for reports being filed late?
All laws under the Ethics Commission's jurisdiction carry the same penalties, and the commission enforces those laws civilly or administratively, and the sanctions for a particular violation include the issuance of a public letter and or the imposition of a fine. The range on fines is $50 to $3,500. There's a provision in the statement of organization, BEC statement of organization statute, that says if one's filed late, it's subject to a late filing fee of not exceeding $50 a day. And then the laws under our jurisdiction also carry criminal misdemeanor penalties, but we would enforce them criminally. That would be up to the prosecuting attorney.
Okay. So, this way.
What did you say the name of the group that filed the reports was?
Restore election integrity in Arkansas.
All right, and then, so then there's another group, and I get, this is, you may have covered this, and I'm just too much for me to comprehend, but AVII is another group that was engaged in the petition signature process, correct? And they're advocating openly to sign a petition.
Are you referring to the sheet that shows them standing?
Well, yeah, so that's my question. If AVII is out gathering signatures, or, you know, I guess taking people, you know, or pushing to, sign or gather signatures for this, what constitutes, and I just don't know, a ballot committee? When you have the $500 threshold, I get it, but what kind of activity do you have to be engaged in?
Well, it's expressly advocating the qualification, disqualification, passage, or defeat. But if you look at the statute, it said qualification ballot question means any action or process, legal or otherwise, through which a ballot question obtains certification to be on the ballot in an election. So if you were circulating petitions, I think you're trying to get it qualified. You're taking actions to get it certified. And so, and so that's when I spoke earlier about kind of depends on where the process you are. I mean, there might not be a certified question yet, and then you just be, okay, well, we're wet dry in a particular county, but then once you got it certified, it's like, hey, this is going to be issued, whatever, or ordinance number, whatever.
But AVII, if you just look at the website and kind of look at what's here, that
Whose
they
website are
are,
you talking about?
this
Mr. Chairman.
Okay, we don't have any other questions at this time, so very appreciate you being here. Might stick around a second if you don't mind. And then, last person on the list. Thank you.
I'm now the treasurer of AIA and its general counsel.
Okay, you're gonna swear you in, okay? Do you solemnly swear or affirm to be truthful? Thank you.
I may remember all the Michael Denny to join me. He is an attorney at Wisconsin who's consulting with me and my law firm in this case.
As long as it's relevant to the discussion today and you're comfortable, come down, be willing to submit himself to questions and be put under oath, that'd be fine.
Yeah, he has no intention to make statements, but he will if you ask him questions.
Very good, thank you.
Also, Senator Hammer, I had some prepared remarks if I could read those.
Yeah, if we can get him to the table and identified, sworn in, I'll recognize for comments, and then we're gonna go to any questions if any members have questions. Good afternoon, sir.
Good afternoon.
And if you would just name and title into that green mic for us, please, sir.
My name is Mike Daniel, and I'm
Yes, sir. Would you raise your right hand? So I'm reading another oath to repeat. You solemnly swear to affirm the testimony about you being truthful, truth, nothing but the truth, so help you God. Thank you, sir. Have a seat. Welcome to Arkansas.
Thank
All right, Clint, first name basis, okay?
Yes, sir.
Okay, if you will, go ahead and whatever statement you want to read, go ahead.
Sure. I would like to thank you again for permitting me to testify before the committee on the very important topics of self-legislation and secure elections. I would like to begin by assuring all members that the statements I make before this committee are under an affirmation to be truthful and honest. In that spirit, I need to clarify my previous testimony, as upon reflection, some of the statements I made were not accurate, even though I believe they were when I made them. First, I either said or strongly alluded that the Arkansas Voter Integrity Initiative, a 501c4 entity, was behind the county-by-county effort for paper ballots. I have since learned that it was not ABII behind the measures, but Restore Election Integrity Arkansas, a ballot question committee. In these reports that we filed this morning, ABII made in-kind contributions to REIA in the form of attorney's fees, and that was the basis for my confusion. Second, after further investigation, as Ms. Justice testified a little while ago, she was not a paid ballot canvasser for REIA, and when I said that or strongly alluded to that in the last testimony, that was not accurate. With those clarifications made, I announced today that over this past weekend, I joined REIA as Treasurer and General Counsel. REIA inadvertently failed to make timely reports regarding its contributions and expenditures to the Arkansas Ethics Commission when they became due. This is something that Representative Ray astutely recognized in the previous meeting. Reports required to be made, they were not timely made, and REIA has self-reported that to the Ethics Commission by an email that I sent Mr. Sloan on Saturday. As of this morning, REIA's late reports have been submitted for filing. REIA understands that filing these reports will not absolve it of the responsibility it has for filing late, but I firmly believe that it is better to file them late rather than never. REIA anticipates continued advocacy for the Independence County measure that will make the ballot this November. I will ensure REIA's reports are timely filed for October pre-election and before it winds up in November. Perhaps you are considering selling REIA. Before you do, REIA would like to bring in two other entities into the arena to make sure that the JPR gets all it can with the fewest stones possible. Starting with the group which calls itself Citizens for Safe Elections. This charming group of ballot blockers did or was running digital billboard ads in Independence County encouraging no vote on the paper ballot ordinance. finances. It is not registered as a BQC or PAC. It has made no reporting of its contributions, in-kind donations, or expenditures. The second group of ballot question blockers is a more nefarious nature. My law firm and his client, Brian Norris, who is here today, possess information that clearly and unequivocally indicates that the Arkansas Association of Counties has been providing ongoing assistance to county clerks in the counties where the measure was submitted to be placed on the ballot. The ANC, as it does so often, has been operating in the shadows as a concrete entity for county clerks who oppose this paper ballot measure. Their operations include litigation strategy, templates for clerks to use, and conduct which was intended to delay or frustrate the placement of this measure on the ballot. However, the AAC has not registered as a BQC, is not a PAC, it has not reported its contributions or expenditures. This entity, which is a conglomerate of lobbyists that receives public funds to operate, provides no accountability for its actions. Please let that soak in for a moment. A group of lobbyists which takes public funds to conduct operations is engaging in ballot question advocacy, spending public funds to defeat constitutional self-legislation at its most local level, and has no accountability to the legislator, the ethics commissions, or the people whose tax dollars fund their missions. I hope you're as angry about that as I am. It is appalling that my tax dollars have been used against me because elected officials do not want paper ballots. It is more appalling that the AAC is doing it in total darkness. Of course, I realize that the AAC is a publicly funded private corporation that is free to advocate for its members and not the people whose tax dollars pay their bills. That does not mean it should be allowed to do so in the dark. I strongly encourage the members of this committee to create legislation which prevents citizens' tax dollars from being weaponized by an entity like AAC to the taxpayers' detriment. Finally, at the last JPR meeting I attended, I heard from a number of legislators who desire to create laws to keep people from out of state from meddling in our elections. That is a double-edged sword. While the legislature works to keep out right-wing liberals like George Soros from coming in and effectuating general primaries or ranked choice voting, it is also preventing people from accessing the ballot to self-legislate. This county-by-county ballot measure was the product of local residents. John Bailey has been a longtime resident of Arkansas and headquarters his multinational publicly traded company, the SR Real Estate Investment Trust, about a block away from this very building. Colonel Conrad Reynolds is a decorated veteran and national security advisor with top secret security clearance. He's also the son of an Arkansas state trooper. I would encourage the JPR to, and I say this to let you know, it is a locally grown initiative, and ask the body to work on a way to keep out-of-state meddlers away while allowing Arkansans to access the ballot. Thank you again, and I look forward to taking your questions.
Thank you, Senator Disney.
Last time you're affiliated, you were only affiliated with API.
Correct. Full candor to you, sir. I did form the real estate or the REIA ballot question committee at the request of its officers. But after I formed it, I took no other action with it, to the best of my knowledge, since I think Friday or Saturday.
Okay, yeah, because that's what I've noticed on October 19th, it was changed to proceed that essentially they were housed in your office, is what it says.
Well, they got their mail there. I mean, you got 4 or 5 different people from living in various addresses across the state. It's just better that they send it to me where I know I can get the mail.
Okay, but you just weren't aware of what they were doing. Yeah.
No, I was not aware. I became aware after we were here last time. There were a number of discussions with my client about the reporting requirements. And so I realized at that time that we do not hide the ball that our reports are correct. They should have been filed. Mr. Sloan was right. The REIA crossed the threshold in June when a donor gave, I believe, $100,000. And then we subsequently took in more money, all the same, and paid it out. We currently have a balance left that we intend to use to advocate in Independence County.
All right, well, you said something about in-kind legal work earlier. Walk me through what that means.
So this is what I I didn't really study campaign finance law in law school, but what I understand it to mean is that ABII paid my attorney's fees. And so when it paid those attorney's fees, it did that for the benefit of REIA. And so that then becomes an in-kind contribution if it is reported in our recent filings.
When did that, so the first time that you didn't know that you were working for them? How is that possible? Now,
Well, so
you were getting paid by ABII, didn't know that REI was doing anything, but you were doing work for REI, but no one told you were doing work for REI because ABII was paying.
So yes,
Did I jump through all the little things correctly?
I never asked for who, yes, I think you did, and I never asked for, the magic legal term was who benefits. I never asked, hey, who benefits from this work? I mean, I'm a very direct person, standard is, man, I don't care about your problem until you pay me, and then I care very deeply.
So what type of work were they asking you to do?
So the work was.
What was the work that you were doing and getting paid for? You were doing it for REI, getting paid for it by ABI. What was that work?
So that work would eventually be lawsuits filed in 9 different counties.
That's all you did. There was no other advising or anything else.
Yes, there was. So when we were considering a statewide ballot measure, I started providing advice about how to do that. And when it switched to a countywide one, I provided advice about how to do that.
When would you and talk about doing the statewide? What's the date on that?
It was in October of last year when we started, and then promptly were frustrated by the Attorney General's office, tried to bring the original jurisdiction that we lost.
So then I would advise that you need to retroactively amend your return or amend your filings back to October, because that's when you need the work for REI that getting paid by ABII in the form of in-kind contributions.
I will look at that. When I studied that, and the question that I thought that I really focused on was I advocating it for it to be on the ballot at that time? And so I'll look at that and make a decision.
Yes, what I understand, I have through all the little hoops, and I understand it's complicated. Your work for REI, the in-kind portion of that, occurred in or about October. Well, it would start recurring back when you filed the ballot, DQC, and you formed it. We're talking about it, and you're doing work and knowingly doing work for REI at that time because you filed the legal work for them, and I guess you just didn't charge them any more than $500 to do the filing.
I don't remember sitting here today what I charged in October of last year. I know that I focused on, does drafting, say, a constitutional amendment constitute advocacy for it to be on the ballot? I don't know that it does. I will have to ponder that and try to sort that out, but that's what the standard I looked at was I advocating for it to be on the ballot?
Okay. All right, thank you. Thank you, Mr. Chairman. Thank you, Mr. Lancaster, for your testimony, and certainly appreciate the corrective action that your group is taking on that. I just have a couple of quick questions, mainly going back to the canvasser issue. So we've now had 3 different notaries either swear or affirm that the addresses of the petition gatherers on the petitions were not redacted at the time that they notarized. But then we had 2 individuals, Ms. Justice and Ms. Johnson, swear or affirm that they were redacted, or sorry, that they did not redact them, and they were the ones that turned them in. So the question that's still left unanswered in all of this is, who made those changes to the forms?
Representative Ray, the only way I know that is what my client told me. And it goes back to the attorney-client privilege doctrine that I've not been authorized. It's not been waived.
Okay, so I'm not going to answer that question.
but you do know the answer.
I can't answer that question.
Okay.
Not in keep a law license.
I understand. So let me ask it a different way. Did you instruct anyone that it was permissible to redact the addresses on those forms?
What I told to my client is covered by the attorney-client privilege.
Okay. Okay. My next question is, are you familiar with the Arkansas statute as it pertains to alteration of a signature on a petition or canvasser affidavit after notarization?
Could you tell me which statute you're referring to specifically?
Arkansas Code 7-9-103 C2.
C2. Let me pull that up. It's not the one that I had. I'm vaguely familiar with it.
Let's see. This is an exhibit number that maybe, I don't know if this is exhibit A, maybe C6. C6. It's on the back of C6. I'll read it. It states that a person acting as a canvasser, notary, sponsor, or agent of a sponsor commits a Class A misdemeanor if the person, quote, prints a name, address, or birthday other than his or her own on the petition, unless the signer requires assistance due to disability. So I would just hope that you're not advising people that that is acceptable. When I think the law is pretty clear that it's not possible.
Let me interrupt members of the state. It's not the state that was from last week. I'm working off my system from last time, but I can take it back. What's the number? It is on back D6. Okay, thank you. Go ahead, sorry.
So I think that that's a question about the interpretation of the law. When I have read this statute, when I read this statute, I don't see, I see this as pertaining to the names of the people who sign. Like, in other words, not the canvasser, the person who signs the petition. That's where your ballot, your petition fraud comes in, is when you're putting down names of people and signatures who didn't sign, okay, who don't exist, and things of that nature. Not when you're correcting something else that the canvasser did. I don't think that applies. But that's a.
There are laws pertaining to who is eligible to be a paid canvasser, but I know you have your own opinions about that. So I know you can't share anything that you discussed with your client. I respect that. Did you yourself make redactions to any of these petition forms?
No.
And then my last question is just about, I know you retracted some of your statements from your previous testimony, but in the previous meeting, but reflecting on what you said the last time you were here, you made a very specific point to bring up Miss Lori Justice in your testimony, and you stated that she was a paid canvasser. And you also sort of went on to say that your role was just to advise legally to the group pushing the issue. And so I'm kind of confused as to why you were so certain that you, out of all the people involved in this effort, you chose her to specifically state that she was a paid canvasser and not anybody else. Why did you do that?
At the time I made the statement, I was under the impression that she was. After the last JPR meeting, I sat down with my client and found out that that was not the case. And so that's why I retracted that statement, and I'll take this opportunity to apologize to Ms. Justice for the incorrect statement.
Okay. All right, that concludes my questions. Thank you.
You're wearing two hats here today. One is treasurer and one is attorney. Is that correct?
Yes, sir.
So you're not an attorney. When I ask you this question as treasurer, were you privy to any conversations as treasurer that would reveal who it is that changed the addresses of the forms as a treasurer?
No, sir, not as a treasurer. However, I possess the reports, and I can discuss anything you would like to discuss about that. We are going to be very open and forthcoming.
You just want the signature sheet.
No, I'm talking about the filings that we made with the Ethics Commission, our reporting expenditures and contributions.
I got three in the queue. Some of them in the order, Representative Wood, Representative Bay, and then Senator Disman. So, Representative Wood.
Thank you, Mr. Chairman. Broadcaster, do you know who wrote the $13,000 check to D2 hotel, motel, whatever, in home in Conway?
Yes, sir, I do.
Can you reveal that?
In my role as treasurer for the REIA, the person who signed that check was Colonel Conrad Reynolds. And from a bank account in the name of REIA.
Okay. Which came first? Is it AAI or is it, what's the initials?
ABII.
Okay. Did it come first or did REIA come first?
Are you, to make sure I'm clear, are you speaking about the time it was formed? When it
No.
come into existence?
You know, at this point, like I said the last time, this is a mess. And then the country has it pretty bad. Now, which one of them, it's not the chicken and egg, which one of them was, did they meet and talk first? I don't care whether it was with the state or who met and who started the discussion. Now, learn that it's involved in Independence County. And then we'll go to someone else referred to 9 counties. Mr. Sloan only has one report or 2 reports. But which one came first? Who is responsible for you and your actions?
I'm not 100% sure I understand your question. Are you asking who directed me to do the legal work?
Well, yeah, well, you can put it that way, or who elected you treasurer. But and what I'm trying to get to is which one of these organizations was established first?
Well, ABII was formed first with the Secretary of State's office, and later on, as it decided to, as the members decided to go out and do advocacy for a ballot position, I was like, hey, you got to be a BQC, you know, but you don't have to report until you take in over $500. So BQC was doing work, and then in June, it opened a bank account in January, and I provided, that was not the threshold reporting requirement, it was only $100. But we still reported that to the Ethics Commission out of an abundance of caution, along with a number of reports showing no activity.
For which committee?
For the BQC, Restore Election Integrity.
Okay.
So we filed all those reports. They're documented, they're itemized. We have itemized expenditures. There's only a few unitemized expenditures that I could not account for, but I believe them to be fuel, and that was marked on the actual report itself. The totals are there of where we're at and what we've done.
So, Restore Election Integrity was the first committee. Is that what you're saying?
It's the only valid question committee that we've done.
The other one's not a valid committee.
The other one,
Yet they pay money to REA or to the other committee for your salary. Is that right? That's what you said earlier.
ABII paid my legal fees. It did so when I discovered that it was doing so for the benefit of REIA. I properly reported that as an in-kind contribution.
But you have to pardon me for my ignorance, but it sounds like a subterfuge all the way around at the expense of the people of the state of Arkansas. They don't know who to look to. And the Ethics Commission didn't know till this morning at 9 o'clock, and you knew y'all had to appear here today.
Well, Representative Wooten, I'll tell you that I spent my entire weekend working on these reports so that they could be filed before this testimony, and so that I can answer questions about it if you have them.
I have questions. I mean, you still haven't made it clear which one of these 2 committees was established first. Did they pay your legal bills before they Restore committee was formed, or did they pay it afterwards? And has that been reported?
So to be clear, ABII is not a committee. It's a Inc. It's a corporation.
Okay.
Okay, so the only committee.
Did they report the paying your legal fees?
Yes, sir, they did. Not timely, but they're reported.
They reported it.
And it's contained in the reports. Along with, I think somebody mentioned 3 vans. Those 3 vans are leased to REIA under a legal contract.
Who paid for them, REI?
You know, I was a little bit speculative too much last time. I don't know for sure, so I'm just going to tell you I don't know. I would be guessing who paid for those.
All right, thank you, Mr. Chairman. Thank you, Mr. Lancaster.
I think you're treasurer for REIA or ABI,
Not ABI, REIA.
and you're attorney for both. Were you paid legal fee? Were you a registered lobbyist for ABII?
Yes, I was. That was not a very successful gig for me.
Okay, okay. So your attorney fees though were paid for lobbying services or for services other than that? Oh, okay, all right. Representative Page.
Over here.
Oh, okay.
Right to your right. Thank you, Mr. Chairman. My question is, we've heard your testimony about clients and attorney-client relationship. Have you provided any records to this committee that specifically spell out who your client is and the date that that relationship began?
I have not provided any such records, no.
Can you provide those records to us?
I do think that would be covered by the attorney-client privilege document. So, because it involves a statement from my client, and it's a very simple statement, you know, will you represent? But without having a waiver, I don't think I can.
Okay, so, I would think that just to back up your statements here on the record that there is an attorney-client relationship between these entities, because there seem to be multiple entities that are out here that you're kind of asserting an attorney-client privilege to, that there would be some supporting document, an engagement letter or something along those lines that would cover that relationship. So I would like for you to provide that after you think about it further and reflect on that, if you see fit to provide those records to the committee. And then a follow-up. We talked about some of the monies that have been expended for other issues. As treasurer, can you disclose the amount of money that has been paid to you for legal fees?
I can. It's on the reports. I can look it up if you like.
Well, yeah, I don't have to report.
Sure. No, I'll look it up and I'll tell you exactly what was reported if you will give me a. So in August, ABII paid my law firm $31,983, bringing their total contribution up to date to be $37,818. Now, I will check that was our busiest month with the number of lawsuits getting filed. Let me check September's for you, sir. In September 2024, our report reflects that my firm was paid an additional $20,230, bringing the total cumulative total from this contributor to $50,000.
Thank you, sir, for that information. I think just a couple of questions. Sure. Going back to the affidavits, I'm not going to say redacted affidavits. I'm going to say altered documents, because that's what it really is. There was not a redaction. It was an altered document. Have you seen those documents prior to your, or given any advice prior to that attorney-client relationship taking place?
No, I didn't give any advice except, well, all that matter except in my capacity as an attorney.
So in your capacity as an attorney, how do you correct incorrect information on an affidavit? You just scratch it out, put anything you want in there and submit the document as original? Or what steps do you take to make certain that the information that is being provided on official documents that are signed by the notary for any matter, how do you make certain that you make corrections on those documents?
So a petition sheet is kind of a unique form of affidavit that lawyers like me don't normally use in the fact of the times when you're getting a sworn statement. What I would normally do if it was a traditional affidavit is bring back an amended affidavit. Much like I said today, correcting the things that were not accurate. In this situation, I don't know. As far as a petition page, my understanding of the law is that there was nothing illegal or improper.
So as an attorney and an officer of the court, any sworn official document that's submitted to a governmental entity, if there are alterations and scratch outs and mark outs, I mean, you still don't think there's any issue with that?
No, I don't, because it's not completely uncommon to see somebody take a line through something that's tied in an affidavit and handwrite their statement. In fact, there's a number of judges that like to do that with court orders. So I don't see that as being nefarious, given the fact that the notary is only validating the signer's identity and nothing else. So I think that there's nothing improper that's occurred.
All right, well, I appreciate your opinion.
Just thinking.
All right, so now when did you start working for REI? When did you become aware that you were working for REI?
I would say this past week.
All right, and then you're not an attorney for REI, you're a treasurer.
Both the treasurer and an attorney.
You're both the treasurer.
Yes, on my amended filing, I'm listed as a treasurer.
Okay. So here's the question, you've said that you got my attorney privilege, right?
Yes, and also yes.
And so, what this is related to is solely dealing with REI. The question is who changed the documents, which is only related to REI. It cannot in any way, because they're two separate entities, ADII, right?
I agree, they're separate entities.
So how do you, but you didn't even know that you had REI as a client until someone told you later on that you had them as a client. So how do you have a client attorney clear privilege on a conversation about the signatures that has nothing to do with ADII, the one that you thought that you had the client attorney privilege with the entity?
Well, I don't think, if I'm thinking of this correctly, nothing to do with the affidavits or their the alleged alterations or redactions, whatever you want to call them. I never learned anything of that from my role with REI as general counsel, especially treasurer.
But ADII should have never had possession of those documents because they couldn't have belonged to them because they belong to the ballot question committee, not ADII, who could not do anything like that.
Yeah, that's a fine technicality.
It's not a technicality. It has to be a technicality because if they're not separate and someone, and I don't think anyone's intentionally trying. I want to back up and just say something very quickly. Y'all can chat if you need to while I'm speaking, and that's perfectly fine. But my question, I don't think any of the members up here are trying to prevent a particular county from having paper ballots. If you all want to legally obtain signatures and the county as a whole wants to vote on it, and that's the direction they want to go, then that's perfectly fine. Even some of us here voted to allow that to happen in legislation. I think, and so for a lot of people that are here that are listening, trying to figure out what's going on, the question is, I think, really the irony of the group advocating for paper ballots, because they have greater integrity than the electronic, offering the documents after being notarized to submit to get what they want. It just really speaks to, that's a problem, right? The same group that wants paper ballots is okay with offering notarize documents before submission. I'm assuming that we have to notarize these paper ballots whenever they're submitted. So this is a background. It's for people that may be trying to pay attention to what's going on here. It isn't so much about paper ballots in the county, it's what your organization or whichever organization it is got where it is, or, got these things before us even. So REI, the way that I understand the law, has to be completely separate and apart from AVII. They do two separate things. There can't be a commingling. So AVII should have never had the privilege to review or touch or see these ballot initiatives or these signatures. So I'm asking you, so you couldn't have represented the entity that you had a conversation with about this. My question is, since you didn't, I mean, how is that protected by attorney-client privilege? Your conversation about documents that didn't belong to this other client, how is that protected? You didn't even know you represented REI.
Well, Senator, I think that you're overlooking the fact that ABII acted as a volunteer for REIA.
But I mean, I'm looking at it in AVI. You just told me that the vans that are rented were rented for REI, but they're plastered with AVII. It's all part of the REI paid for the vans that AVII used, according just to what's on the vans.
The vans are owned by ABII. They were leased to REIA.
Oh, I didn't catch that initial part. They're owned by AVII and then rented to REI. I just thought that there was a legal contract to rent the vans, not who the originating entity was that owns the vans.
Yes,
Okay.
I'm also, that's listed on the expenditure reports as an in-kind contribution.
They are now.
Yes, they are.
Yeah, okay. But so you didn't represent REI, but we're going to go ahead and say that we've got attorney-client privilege for an entity that you didn't represent until just a little bit ago.
There's no way that I can answer that question on REIA's behalf and not violate the attorney-client privilege I owe to APII. So I know that that's.
So whenever y'all were having this conversation, it was clearly that I'm AVII having a conversation about REI, but we don't talk about what was happening. You got the privilege to not speak about this to anyone else. What you're saying doesn't make sense, but I understand there's a lot of, we jumped through all the hoops a minute ago to kind of backtrace to where we are. I mean, you're in a very complex pretzel. And in a way, I appreciate it because I think you're trying to navigate the best you can. But it just leaves holes in almost every way we try to have a conversation. I mean, I guess I would say I don't really know. The question is, who changed the documents? You said twice now that you're not willing to say. Okay. I would just, that's all I want to know.
Question, when you were here last time, the client privilege, attorney privilege that you invoked not to answer questions last time you were here, were you here and did you make that statement as the attorney for REIA?
No, because I was not involved at that level with REIA at that time.
So last time you were making your attorney-client privilege as AVII.
AVII and any of the other clients that I had discussions with.
So if last month we would have asked you about who altered the documents from a REIA perspective, you would have been able to answer the question then, because you stated just a second ago that you're not their attorney, or you weren't aware that you were their attorney until last week. Is that correct?
So I was not aware that I was providing legal services for the benefit of REIA, but I officially became their attorney over the weekend.
Okay.
And I appreciate, Senator Gisman, it is a complex situation. I will say that you should have been there when we looked into Hunter Biden's finances, because it was an equally complex situation as well.
All right, let's go to Representative Ballots next.
Thank you, Mr. Chairman. So how many people are on the committee, on your committee? The committee one,
The
not the
BQC,
Inc., but the committee, how many people?
I believe 5 total, but I'm not looking at that record, but I believe 5.
Is that for anybody to be able to see?
Yes, ma'am, I can tell you who the members
So
are.
my next question is, are you a lawyer for all of those people on that board?
Yes,
on that
ma'am.
committee?
I think I am, yes.
How many people are on your Inc. board?
I don't know that information.
But you should. You just said you're their lawyer.
I don't know. Maybe that's possible, but there's not been a problem with the Inc. board. As you can kind of glean, I'm kind of involved when there are problems.
No, I refrain from saying what I was there. So they all have client lawyer privilege with you, is what you're saying.
I've consulted with all of them in a legal capacity.
And they've all paid you personally.
Well, again, without getting into how my firm gets paid, it doesn't require a payment for an attorney-client privilege to attach. But I have to be compensated for my services.
And you can't tell us who compensated you for your services.
Well, I feel like your question is wrong.
Okay, so if it was for the board, who compensated you for the board?
For the BQC or the
one that's the Inc.
The Inc. I was compensated by ABI.
And who compensated them? Who gave them the money to pay you?
Okay, so ABI is a 501c4 organization. It does not have to disclose its donors.
Thank you, Mr.
Debate.
Back over here.
Yes, sir.
Since we have you here, I feel like it's a little information I'd like to know. In your capacity as treasurer for the entity that you represent and said you're treasurer, my question is, have any been expended lawsuits against the Republican Party of Arkansas, particularly Luther Souder and that group?
You mean my wife's loss? Yes. None of the money for REIA has been distributed as an expenditure of any kind to that particular matter.
Thank you.
Representative, no, sorry. Senator Dismayne. Representative Wooten, light back up, please. I got it wrong order. All right, Senator Dismayne, and actually I'm gonna go Senator Rice, then Representative Wooten.
You have me intrigued with your, just being comparable to Biden's finances. I'm not sure that's the best analogy I would want to use again, but I do appreciate you making it. Because I do feel like it's fairly complex with what we're talking about here, and I don't think it needed to be complex. I think that trying to figure out how to backdoor fix something is what's made things complex. So, and again, I'm not sure that anyone's doing it on purpose. I'm just saying, lack of knowledge, sometimes happens, and you're trying to fix a lack of knowledge, and rather than just kind of acknowledging that we made a mistake, that's fine. And so, but again, for me, it's all central to this changing of the notarized documents. And I think we do have a very different opinion on if that's the right or wrong thing to do. I think especially in the context of what we're talking about, this leading to, it's even that much more important. I would think for anybody that the documents can be changed after submission or just prior to submission without the knowledge of everyone that is involved in the creation of those documents. So my question is, but you're now a treasurer and an attorney for, let's just say that the Ethics Commission wants to bring you all forward, or some other entity does, it just wants that to choose the documents. You now have an obligation to sign on as treasurer. You're tied into the bunch. You're no longer just you no longer just have a client attorney privilege. You're part of the team. My question is at what point do you disclose that? Because I think, if I'm on a team, and I know that, is there only one person that knows the answer to this question?
I don't know. I don't think so.
Okay. Could you direct, who all, so I think we said that Conrad knows, who else would know? And your position as treasurer, you've had these conversations, because clearly you wouldn't be part of a group that would, not follow your advice or whatever it may be. Who else would know about the changing of the documents?
So my capacity as an REIA is primarily financial and campaign finance. So
that's not true. You said very very, very much otherwise earlier today. You said that you paid ABI for the lawsuits, and it pays substantial amounts of money. I've just glanced, but it's not minimal amounts of, at least I don't know. I'm not, again, not an attorney. I don't know how much y'all get paid, but it's a lot, in my opinion. So that was just for financial, because you just said your responsibilities with REI are predominantly financial.
That's in my capacity as treasurer, yes.
So you're not some part of some group, there's no overall votes, minutes, discussion, this just operates now.
Well, a BQC is not required to maintain the formalities of the meeting. So there does not have to be meetings, there does not have to be minutes, no quarterly board meetings. It functions just simply as a reporting entity. And my role with them is now to report their finances and guide them through the campaign finance problem that was created.
But prior to that, it was the lawsuits in the counties and all the other things that come with that. And so you pivoted now to where we're predominantly treasurer, even though you weren't predominantly treasurer, you just didn't have to know what you were doing at the time that you were working for. It's very, very complex. And I don't really understand. I guess you can assert that privilege all day long. It doesn't make sense to me. What difference does it make? You don't even think it was the wrong thing to do. And you know that more than one person knows about it, evidently, but yet we say, I don't understand it. And now you have a responsibility as treasurer, as part of an organization. You would think you would want to be a part of an organization that doesn't change documents. What if that happened to you?
Again, I do not think there's anything nefarious about changing an address. I mean, obviously, we disagreed on that. But, so what I would ask.
Then why are you invoking the privilege?
I would posit it this way. I learned the information in my capacity as an attorney regardless of who I was representing. And I owe that person. But I have an attorney-client relationship with that entity.
And that individual did not release you without obligation after the last meeting's testimony.
Okay.
They said, we don't want anyone else to know about this.
No, they didn't say that.
You had a conversation about it.
We
You
had
can't say that because you've got client attorney privilege. I wouldn't answer that question if I were you.
Well, there was a conversation, the contents of which I cannot divulge, but there's been no nefarious, like, oh my gosh, Senator Ismay asked such difficult questions, Clint. Don't waive attorney-client privilege because we don't want them to know. That's not the case at all.
But why are we waived? Why?
Because it's just not been waived. I can't waive it.
One person knows about something, but 2 people know about something, or 3 people, we don't know how many people know. And you're just saying, and we don't even think it's illegal. The person that did it doesn't think it's illegal. No one thinks it's any big deal whatsoever on the other side of the, the argument, opposed from, what I believe to be the case. But no one's willing to disclose it either.
At least not me.
Okay. Thank you.
Senator,
I'm sitting here listening to this. I didn't have as much problem as it is going to go, but I understood you to say that you really don't know who all your clients are. If somebody's grand or grandmother knows the answer to the question, we want to know who it's not a part of the organization. You don't know, but you're okay with them saying they've got attorney-client privilege with you.
I'm okay.
That's what I hear you saying. Anybody just tell me, Clint Lancaster, and you've got attorney-client privilege.
I'm so glad it doesn't work that way. I think that if that was the impression I left upon you, Senator, I left that too broad. What I am saying is that the board members of ABII and the directors of REIA have all consulted with me, both in their capacity as officers of those companies and personally as well.
Those should be identified identities.
But
That you know who they are. Maybe you can't recite them right here
I
today.
can't recite right.
But I don't need to know. I'm just saying that's an entity that you have a relationship with. But what I believe a while ago, you said something about you didn't know who all was in some of the organizations. And I just don't want people using that for an excuse, because it's like saying I'm going to sue you. I'm going to get an attorney and sue you. And they didn't sue you till I do it. But I don't want to claim a privilege if they're not part of the organization you're representing. at least from your.
I agree. If I have not provided them any type of consultation or formed a relationship, they should not be able to say I have attorney-client privilege.
I just want you to be clear in your speech, but they know that, so that's the reason for my question. Thank you.
Yes, sir, and I would be happy to disclose the directors of the ballot question committee.
Representative Grable. Thank you, Mr. Chairman. Just real quickly for Mr. Gable. Is it Mr. Gable? Is that
Hello, Representative. My name is Mike Gable, Gableman.
I'm sorry about that. Okay, so I'm just curious, what is your role here?
Well, thank you, Representative. My role is someone who's very, very concerned about election integrity and security. After I left the Wisconsin Supreme Court, I served for one term, a 10-year term. I did not choose to run for re-election. Not too long after I did not run, the Wisconsin Assembly hired me to investigate the 2020 election in our state. Mr. Lancaster was the President House legal team in Wisconsin. In that capacity, I became familiar with him, and I hired Mr. Lancaster to work on my investigation. I'm down here because I'm very concerned about what appears, Representative, to be a weaponization of the legitimate political purpose of a committee like this. I've looked through the description of your committee as it appears on the Arkansas Legislature website, and it has broad power. Nowhere does it say, contrary to your opening statement, that it should serve as an investigative arm of law enforcement. You have the power, you know better than I, to refer questions to different committees, but nowhere in your opening statement, Representative, you mentioned you are looking into criminal laws that may have been violated. You use the word fraud and being the Class C felony. That does not seem to be legitimate exercise of political oversight of agencies. That appears to be a witch hunt in order to intimidate the supporters of paper ballots. One of the senator there, Senator Dismay, mentioned the word irony. Your great state, and I do mean that, this is a great state, and I have great respect for all public servants. Regnat populist. People rule. Exhibit C2, I see a band with volunteers. I don't know if they're volunteered or they're paid, but what a wonderful attempt for the people to rule themselves, and what an odd use of a legislative committee's time to attempt to investigate criminal activity that it views as criminal, even at your first hearing, which I watched every minute of it, 2 or 3 hours, something like that. If you were looking into the issues that need to be addressed by future legislation, which you neglected from your opening statement, I know the chairman made sporadic comments during the hearing about the legislative oversight process, which is the actual function of this committee according to its charge. You had all that information at the end of the first hearing. Now it seems to be a question of trying to get a lawyer to violate his oath and to subject themselves to the penalties of whatever regulatory body regulates lawyers in this state, and also to betray his client's confidence, all in an effort to find out the identities of people who may have done something that it's debatable whether or not even if it was an infraction. That just seems to be such a perversion of the legitimate legislative process. As someone who devoted 30 years of his career, I was either a prosecutor or a trial court judge or a member of the Wisconsin Supreme Court. I find that grotesque. And that's why
I appreciate your opinion on the Arkansas legislative process. We do make laws in the state, many of them pertaining to the initiative process. And so if they're not working as the legislature intended, then we need to make revisions to those laws in subsequent legislative sessions, and that is what we're doing today.
But that has nothing to do
Well,
with who did what.
I'm not going to debate it with you. But I will move on to my next question, which is, do you know who altered the petition?
I certainly wouldn't tell you.
Okay, all right. Last question, are you licensed to practice law in Arkansas?
I am not.
Okay, that's all my questions, thank you.
Representative Woodman.
Well, Mr. Chairman, I'm gonna make a fool of myself. Mr. Gilmeister, I'm gonna tell you one thing. We don't need somebody from Wisconsin coming down here and running his mouth. I don't care if you're the Supreme Court justice of the U.S. Supreme Court. We don't need to hear from that. And number one, you're not licensed. You sit there and smirk and smile all you want. But Representative Gray asked you the question I was going to ask. Do you know who gave the instructions to alter the petitions?
There is a lot in your statement followed by a question. And your main issue
No,
of
my
offense
question, no,
seems to
my
be that I
question,
read you the
my
old
question to
law
you,
that's
my
supposed to
question
govern
to
this.
you, Mr. Chairman, the witness is not answering the
This is a
question.
lawless proceeding, and it is a weaponization. It is a weaponization of the local legislative process, and you should stop.
Your point of order. Hang on.
My point of order is, he's badgering a witness who's asking him a question that is a member of this committee. My second point of order is he is not staying on the topic of the questions that he is being asked.
Very
Thank
good.
you.
I'll recognize that point of order, and here's what we're going to do. Representative Woodman, would you please ask your question, and then I will ask you, Mr. Tableman, just simply answer the question, and then we're going to move on. Representative Woodman.
Do you know who is involved for altering the documents that are before us that we're looking into?
If I did, I would tell you.
And I can accept that. Because generally, when somebody uses that phrase, they know who did it. So you can be prepared to be involved in a court case. Thank you, Mr. Chairman.
Moving on to Representative Walter.
Thank you, Mr. Chairman. My question is for Mr. Lancaster. Okay, so, I'd like for you to educate me temporarily, I guess, a little bit on this ballot initiative. So this initiative was formed out of an abundance of transparency in the voting process, correct?
Initially, yes. The thought was it was better to form and not need to report, and not have to report. It just got off the train tracks.
Okay. And to follow up on Senator Disbrand's point, and I agree with you on whatever a local community votes to do, chooses to do, wants to do, I'm great with that. I guess the irony I agree with him on is a transparency initiative is not been very transparent in this process. And I guess my question for you, sir, have you asked your client to waive privilege in this case so you can clear this up?
No, I have not.
Is that something you'd be willing to do?
I'm sure I'll ask. I don't know what the answer will be, but if you're trying to cut down a tree here with a toothbrush, there's an easier way to do this.
Okay, follow up, Mr. Chair. When you said a while ago, the people that present on the boards, on the commission, how many folks do we think that we're dealing with here? Do you have a rough number?
I have their number. I do have a rough number, and I have their names.
Okay, what's the number of people?
I believe it's 5.
Okay, are you willing to ask all 5 of them to waive privilege?
Probably not, no.
Okay. Would one person be able to waive privilege and you be able to divulge that on behalf of the organization?
That's possible.
Thank you, sir.
Senator Clark.
Thank you, Mr. Chairman.